Good day, sir. I'm Karen J. Filicano from BSN Math 2B. I will tackle all about the intellectual property on the development and use of digital materials. Learning objectives. Identified examples of intellectual property right in educational setting. Define the copyright law. Cited consequences when copyright laws were violated. So, according or that according to the plagiarism.org, they reported that a survey of over 63,700 as undergraduate and 9,250 graduate students over the course of the years 2002 to 2005, conducted by Donald McCabe, Rutgers University, revealed the following. They revealed the following. First, 36% kuno of undergraduates admit to paraphrasing, copying few sentences from internet source without footnoting. 24% put of graduate students self-report doing the same. 38% admit to paraphrasing, copying few sentences from written source without footnoting. 25% of graduate students self-report doing the same. 14% of students admit to fabricating, falsifying a bibliography. 7% of graduate students self-report doing the same. 7% self-report copying materials, almost word for word from a written source without citation. 4% of graduate students self-report doing the same. 7% self-report turning in work done by another. 3% of graduate students self-report doing the same. 3% report obtaining paper from term paper mill. 2% of graduate students report doing so. So, mao na ang report according to plagiarism.org. They reported that there's a lot of plagiarism nga nahitabo. So, the Josephson Institute Center for Youth Ethics survey 43,000 high school students in public and private schools and they also found that 1 out of 3 high school students admitted that they used the internet to plagiarize an assignment. So, intellectual property right. So, according to World Intellectual Property Organization or WIPO or WIPO, that refers to creations of the mind such as inventions, literacy, and artistic works, design, and symbols, names, and images used in commerce. So, intellectual property rights are legal rights that provide creators protection for original works, inventions, or the appearance of products, artistic works, scientific developments, and so on. So, basically speaking, intellectual property rights are a common type of legal IP protections for those who invent. So, the purpose there sa intellectual property is to encourage new creations, including technology, artwork, inventions that might increase economic growth. So, intellectual properties right increase the incentives of individuals to continue to produce things that further create job opportunities. And new technology will enabling our world to improve and evolve even faster. So, um, an intellectual property right is a right held by a person or by a company to have exclusive right over this. So, internationally, this intellectual property are protected by the World Intellectual Property Organization, to which the Philippines is one of the 191 member states. So, in our country, we have the Intellectual Property Office of the Philippines, or what we call IPOPHIL. which administers and implements state policies in relation to intellectual property. This office was created through Republic Act 8293. This act defines intellectual property to include copyright and related rights, trademarks and service marks, geographic indications, industrial designs, patents, layout designs or topographies of integrated circuits, and protection of undisclosed information. So in the education setting, copyright related rights are the ones applicable. So copyright. Copyright refers to the legal right given to the owner of the original work or intellectual property. So these works are original intellectual creations in the literacy and artistic domain protected from the moment of their creation. So copyright is a type of intellectual property that protects original works of authorship as soon as an author fixes the work in a tangible form of expression. So they have following creations that we can uh, justify that we can copyright. First, we can copyright in books, pamphlets, articles, and other writings. We can also copyright in periodicals and newspapers, in lectures, sermons, addresses, dissertations prepared for oral delivery, whether or not reduced in writing or other material forms. We can also copyright in letters, dramatic or dramatico-musical compositions, choreography works, or entertainment and dumb shows. And we can also copyright in musical composition with or without words. Works of drawing, painting, architecture, sculpture, engravings, lithography, or other works of arts. Models or designs for work of arts. Original ornamental designs or models for articles of manufacture, whether or not registrable as an industrial design in other works of applied art. Illustrations, maps, plans, sketches, charts, and three-dimensional works relative to geography, topography, architecture, or science. And we can also copyright in drawing or plastic works of scientific or technical character. Photography works, including work produced by a process analogous to photography, lantern slides, and we can also in the audiovisual works and cinematography works and works produced by a process analogous to cinematography or any process for making audiovisual recordings. We can also copyright in pictorials, illustrations, and advertisements, computer programs, and other literary, scholarly, scientific, and artistic works. So, ito ang different kuan na pwede na itong ma-copyright. So, copyright. The internet is a very rich source of these materials, and we should be careful by using them. These works are protected by the sole fact of their creation, irrespective of their form as made of creation as well as of their content, quality, and purpose. Now that copy and paste are very accessible commands in our computer toolbars or sa atong cellphone also, we can use copy and paste. So, we should try not to violate the copyright laws, otherwise, we could be accused of copyright infringement. So, copyright infringement is the use of works without permission where the copyright holder has the exclusive right to reproduce, distribute, display, or perform the protected work or to make derivative works. Paper citation should be used when including them in our output. So, copyright infringement is the use of works protected by copyright without permission for a usage where such permission is required, thereby infringing certain exclusive rights granted to the copyright holder, such as the right to reproduce, distribute, display, or perform the protected work or to make derivative work. So, below are the guidelines on online use of copyrighted materials according by Smaldino, Lauder, and Russell, 2012. So the first guidelines on online is contrary to popular opinion. All material on the internet is copyrighted unless stated otherwise. It is copyrighted even if it does not display the copyright symbol. My first guideline. The second guideline is an email is an original work fixed in a tangible medium of expressions that is covered by a copyright. Hence, it is recommended that you should not forward any email without the permission and consideration of both copyright and the Privacy Act. So the third one, downloading an article from a newspaper website, making copies and distributing them to your students prior to a closed discussions on the topic is permissible following the current photocopying guidelines, which permits making multiple copies for classroom use. The exceptions would be individually bylined copyright articles or articles from a source specifically designed for the educational market where such articles cannot be copied legally for class distribution. Adapted from Beaker, 2003. The fourth one, you cannot post student essays, poems, or other works on the school website unless you have a permissions of the students and their parents or guardians. So, dili ka ka-post sa mga essays, sa mga anang gibuhat sa imong student without kanang permission sa estudyante or sa ilang parents. So, the fifth one, educators should treat copyrighted materials from the internet the same way they do to print formats. The best guideline is to always obtain permission when an adult asks. So, muna ang mga guidelines sa copyrighted materials. So, copyright infringement versus plagiarism. So, we all know that copyright infringement is the use of works protected by copyright without a permission for a usage where such permission is required, thereby infringing certain exclusive rights granted to the copyright holder, such as the right to reproduce, distribute, display, or perform the protected work or to make derivative works. And plagiarism is a representing someone else work or ideas as your own, with or without their consent, by incorporating it into your work without full acknowledgement. So, another violation on intellectual property is plagiarism. Although plagiarism and copyright infringement are related ideas, these two are different. So, lanlain sila. Ang sa plagiarism, according to plagiarism.org, is an act of fraud. It involves both, pareha sila nga, there kanang involves about stealing someone else's work and lying about it afterward. Plagiarism.org further elaborates the following as plagiarism. So the first one, turning in someone else's work as your own is one of a plagiarism. Copying words or ideas from someone else without giving credit. Failing to put a quotation in quotation mark. Masin silang butang og quotation mark. Giving incorrect information about this source of a quotation. Changing words but copying the sentence structure of a source without giving credits. Copying so many words or ideas from a source that it makes up the majority of your work, whether you give credit or not. See our section on fair use rules. So, dapat kung mukopy ka or mukaan ka sa usa ka example thesis, may good about one, you must put a kinsay kinsay nagbuhat, kinsay author, i-must isulti jud nimo siya para di siya matawag nga na you are plagiarism or you are kanang copyrighted to that things. For images, videos, and music, the following are counted as plagiarism. So, matawag siya nga plagiarism kung ang copying media, especially images, from other websites to paste them into your own papers or websites. The second one is making a video using footage from others' videos or using copyrighted music as part of the soundtrack. Usa po na siya sa kanang plagiarism. Performing another person's copyrighted music, like kanang playing a cover. Usa po na siya. So, last one is composing a piece of music that borrows heavily from another composition. So, in other words, plagiarism refers to copying the work of another and claiming it as one's ideas or without proper attribution, while copyright infringement is copying one's work without obtaining permission. Ang sa plagiarism kay kuan man, copying the work of another and claiming it as one's idea or without proper attribution, while ang copyright infringement kay copying one's work without obtaining permission. So in this sense, copyright infringement is a violation of the right of the copyright holder, while plagiarism is a violation of the right of the author. So we have to note that not all authors are copyright holders. There are cases when the publisher owns the copyright. So in addition, copyright infringement is a legal violation, while plagiarism is an ethical violation. So, the questions and the answer. So, that's all. Thank you.